following videotape prepared by the Los Angeles City Attorney's Office is intended for educational and training purposes. The scenes depicted in this video are fictional, and any similarity to actual events is merely coincidental. This video highlights best practices for the governance of community boards and describes general principles of California law that apply to the operation of neighborhood councils currently functioning as part of the Los Angeles citywide system of neighborhood councils. By nature, best practices will evolve as the law changes over time. Application of the law, moreover, is highly contextual and often fact-specific. Therefore, viewers are cautioned not to rely on, apply, or interpret the legal principles contained herein to a particular situation or in a given circumstance without first consulting with your legal counsel.
Hi, I'm City Attorney Rocky Delgadillo, and I'm proud of your interest in our Los Angeles community. And I look forward to working with you in your capacity as a representative of your neighborhood council. You will have a tremendous opportunity to address the unique needs of each of the diverse communities that make up this great city. Together, we will ensure that Los Angeles will be a better and safer city, block by block and in every neighborhood. Welcome to the city family.
This is a neighborhood council meeting in progress. It looks like some of the board members are missing, but the majority of the board is here so they can make decisions on behalf of the council. Now, the size of your board may be different, but for this video, there are 7 members present. Did you know that this meeting, as with all neighborhood council meetings, is governed by a specific state law? It's called the Ralph M. Brown Act, or otherwise known as the state's open meeting law.
Excuse me. Sir, you in the back. Can you please keep it down? Thank you.
Hold on just a second. Now that's better. So you're probably asking, what is the Ralph M. Brown Act? Well, basically, it's a state law that governs open meetings for local government bodies. It establishes rules designed to ensure that the actions and deliberations of commissions, boards, councils, and other public bodies of local agencies are made openly with public access and input. Now you're probably asking yourself, what did he just say? Let me put it simply. The Brown Act is a state law that governs open meetings for local governmental bodies. The Act ensures that all meetings of commissions, boards, committees, or other bodies of a local agency are open to the public with access and input. Does this include neighborhood councils? Yes, it does. The Brown Act governs the meetings of legislative bodies, including advisory bodies that are created by charter, ordinance, or by formal action of another legislative body. Because the city charter created the system of neighborhood councils and the ordinance governing the system mandates certification or recognition by the City of Los Angeles, they are subject to the Brown Act. Once certified, all neighborhood councils in the City of Los Angeles are considered local governmental agencies covered by the Brown Act and must hold their meetings subject to the rules of that act. Now, what is a meeting? A meeting is the gathering of the majority of a neighborhood council board, standing committee members, or whatever number of board members can make a decision on behalf of your neighborhood council at the same time and place to hear, discuss, or act on matters within your jurisdiction. The Brown Act requires that all neighborhood councils establish a time and place to hold their regular meetings. All the meetings must be open, not only to members or stakeholders of your neighborhood council, but to the general public. Now, only at these public meetings can neighborhood council business and agenda items be discussed and decided. In other words, a majority of board members cannot go out, for instance, to a restaurant to discuss agenda items or any matters within their jurisdiction without noticing that gathering as a meeting. Discussion and actions of the neighborhood council board must be taken openly. That means the decisions or votes cannot be taken by secret ballot. And discussion and action on matters can only occur if the item is listed on the agenda for that meeting. Under the Act, people may attend meetings without being required to sign in or provide any information as a condition of attendance, nor can a fee for attending a public meeting be charged. At the meetings, members of the public have the right to address the board members by making general public comment about matters within the jurisdiction of the neighborhood council. Members of the public also have the right to make public comment about matters listed on the agenda before the board takes action on them. Neighborhood councils may use speaker cards to control the flow of public testimony without violating the registration prohibition. Members of the public also have the right to receive materials that have been circulated for the board members to review. If they wish, Any member of the public may record meetings or take pictures as long as it's not disruptive. As a general rule, the location of neighborhood council meetings must be held within the boundaries of the neighborhood council area. Neighborhood council meeting facilities must be accessible to all members of the general public, including persons with disabilities. Along with compliance with state law, this means that facilities must fully satisfy the requirements of federal law, the Americans with Disabilities Act of 1990. And neighborhood council meetings cannot be held in facilities that prohibit the admittance of any person based upon race, religious creed, color, national origin, ancestry, or sex. The Brown Act also requires the neighborhood councils to post the meeting notice and agenda. Meeting notices for regular meetings need to be posted at least 72 hours prior to the meeting. The notices must be accessible for viewing during the entire period to satisfy the notice provisions of the Brown Act. If it's a special meeting, then the notice needs to be posted 24 hours prior to the meeting, and members of the media must be given notice if they have made a written request for it. The notice must include a description of the agenda items for that meeting. The agenda items must be specific and not vague. As an example, if an item is about the concerns of accidents due to street racing, its description should say something like, "Discussion regarding concerns about the growing number of accidents due to Saturday night street racing on Main Street." You can post your neighborhood council's meeting notice at the posting locations you agreed to in your certification application or have set forth in your standing rules. You can also post at the meeting site, your public libraries, city hall, and public bulletin boards. Posting on telephone poles, street lights, or city street signs violates the city's municipal code. The Brown Act was enacted to ensure that the public's business is conducted openly, and the courts take that act very seriously. Violations can carry misdemeanor penalties which are prosecuted by the Office of the District Attorney. Violations of the Brown Act can also result in a civil lawsuit being filed. This can result in your decision being set aside by a superior court judge. Now let's take a look at the Brown Act in action.
I can't believe another robbery occurred at Main Street Park.
Hello?
Hello, Peter? It's Mary from down the street.
Oh, hi Mary, how are you?
I'm good. But listen, I was just noticing in the neighborhood council flyer that I have here that you're the president of our neighborhood council, and I'm really concerned about crime at Main Street Park, and I thought it would be a good idea to give you a call to see what you can do about it. I think it would be a good idea if we could put some lights in the park. I think that would help to deter crime, and I'm hoping that you could get it put on the agenda at the next meeting.
Well, Mary, that's a good idea, and as the president of the council, and according to our neighborhood council bylaws, I can set the agenda. Unfortunately, the agenda for the upcoming meeting is already posted, but you can certainly come to the meeting and bring this up during the public comment section of the agenda.
Oh, okay, that's a good idea. I'll do that. Bye-bye now.
Now, Mary did the right thing. Since this communication is between Mary and only one board member, in this case the president, this is a perfectly acceptable communication under the Act. One other thing about your agendas. Not only should there be an opportunity on each item listed on the agenda for the members of the public to comment on before the board votes, there should always be an item on every agenda for your regular meetings that provide for an opportunity for the public to make general comments regarding matters of community concern. That provides a way for people from the public, like Mary, to raise issues that the board may wish to place on its agenda in the future for its consideration. What's also important is what the president does with a suggestion Mary just gave him. Let's take a look at a few scenarios.
Honey, can you give me a hand?
In a minute. I'm busy writing an email to the board members about Mary's idea to put up lights at the Main Street Park. Actually, I think I can get them to make a decision right away.
Hold on a second. The president should not email a majority of his fellow board members to persuade them to make a decision. This would be the holding of a serial meeting. A serial meeting occurs when a series or chain of communications among a majority or quorum of your neighborhood council occurs outside the public forum.
Maybe I'll call the executive assistant of the board, and he can poll the board members now.
Yes, this is also an example of a serial meeting. The Brown Act does not allow an intermediary of the board to engage in these types of communications among a majority of the board members with the goal of coming to a decision outside the public eye, or even to receive information that may lead towards consensus on a particular matter.
I bought a motorcycle the other day. Great deal. I found it in the newspaper. I can't wait to get out on the road on this baby. By the way, I got a call from Mary the other day. She's really concerned about the crime over at the Main Street Park. She's hoping the neighborhood council can do something about it. Maybe we can put up some lights. What do you guys think about that?
I don't know, is it really that big of a problem? I mean, as board members, we've really got a lot of issues on our plate already.
Well, Mary seems to think it's a problem, and she believes the lights will really deter the crime.
Maybe so. There's some of the other board members over there. Why don't you go see what Cliff and Ani have to say about that?
All right, I can do that.
Now, what's wrong with this scene? This is another example of a serial meeting. The president and 2 board members can have this conversation without violating the Brown Act because the 3 of them do not constitute a majority of their board. But once the president engages in the same conversation on the subject with 2 more board members, a communication with the majority of the board will have occurred, and that is a violation of the Brown Act. All right, let's try this scene again.
I bought a motorcycle the other day. Great deal. I found it in the newspaper. By the way, I got a call from my neighbor Mary the other day, and she's really concerned about the crime over at the Main Street Park. She's hoping the neighborhood council can do something about it. Maybe we can put up some lights. What do you guys think about that?
I don't know, is it really that big of a problem? I mean, as board members, we've really got a lot of issues on our plate already.
Well, Mary seems to think it's a problem, and she believes the lights will really deter the crime.
As a board member, I say we forget about the lights and let's stick to repaving 2nd Avenue.
I think I agree with you. There are a lot of problems in that park, and lighting's not going to solve them. No offense to Mary, but I don't agree. I think the glare will cause more problems with other people's homes.
Well, you make a good point. I don't think I'm going to support this either.
All right, now what's wrong with this scene? It's a clear violation of the Brown Act for a majority of the board to discuss this matter and come to a decision on an issue outside the public eye. These board members have already agreed to the action they want to take on a particular item. Let's try this one more time.
I bought a motorcycle the other day. Great deal. I found it in the newspaper. I can't wait to get out on the road on this baby. By the way, I got a call from my neighbor Mary the other day, and she's really concerned about the crime over at the Main Street Park. She's hoping the neighborhood council can do something about it. Maybe we can put up some lights. What do you guys think about that?
You know, I really don't think we should even be having this conversation. There is a majority of our board here. I think it's an issue that needs to be taken up at neighborhood council meeting.
Now that's the proper way to handle the situation. Not all gatherings of a majority of a neighborhood council board would be subject to the Act. Purely social events or attendances at conferences are allowable as long as the majority does not discuss neighborhood council business. The Brown Act is set up to allow public access and participation. All right, hot dogs are ready.
Hello, welcome. Thank you. Hi, good evening. We'd like you to fill out this mailing list if you'd like to get some information about our community events.
Actually, I just wanted to make general public comments tonight.
Okay, if you'd like to do that, can you complete this speaker card? They will take your public speaker card and call your name during the meeting.
While the Brown Act provides that a member of the public may not be required to sign in as a condition of attending a public meeting, it is appropriate to ask people to voluntarily provide information or ask them to sign a mailing list. Asking people to sign a speaker card is also allowed under the Act because this helps the board organize its meeting and organize the order of members of the public who wish to speak.
There you go.
Thanks. And here's some material that's going to be discussed this evening.
Oh, thanks. You know, come to think of it, I think I would like to be on the mailing list.
Okay, great. If you just fill out your information right here.
Okay.
Thank you. Slide.
Okay.
I'll get you some.
Under the Brown Act, when a majority or a quorum of the board is present, they can conduct neighborhood council business. Now here, the board is going through each of its agenda items based on the notice that we saw posted. On every agenda item, members of the public have an opportunity to comment before a vote on the item that is taken by the board. Each agenda of a regular meeting must also provide for an opportunity to make general public comment on matters that are not specifically listed on the agenda.
Mary Sheldon?
It looks like they're starting general comments now. Let's listen.
Thank you. Good evening, board members. I think most of you know me, as we are all neighbors. My name is Mary Sheldon, and I live at 5555 Brown Street. And I'm here because I'm really concerned about Main Street Park. I called the president the other day and told him my concerns about the park, and he said I should show up today to address my neighborhood council. The park is really becoming a crime problem, especially at night. There are gangs roaming around, there's lots of drinking, lots of partying, lots of noise, and I just think it's becoming a real problem. I'm myself afraid to walk my dog at night around that park. And I know the neighborhood kids used to play around there, and they're really intimidated by the gang members. So I'm asking the board to see what we can do about this. I think maybe asking the city to put up some lights at the park would help the problem, maybe deter the crime, the gangs wouldn't hang out there. So I hope that you can consider this recommendation and maybe do something about this. And that's pretty much all I came to say tonight. Thanks for your time.
Thank you for coming, Mary, and bringing this very important matter to the attention of the board. I, for one, would be in favor of having the city put up lights at the Main Street Park.
Well, let's discuss this a bit. I think our immediate need is to repave 2nd Avenue. After all, the city's on a tight budget and won't be able to do everything for all of us.
I agree with the president. Crime is a bigger concern. I think we should go ahead and take care of this park issue before things get out of control.
Annie, Cliff, what are your thoughts on this issue?
I would vote for recommending that we get the lights.
I agree.
I agree.
Do I hear a motion?
I move that we recommend to the city that lights be installed in Main Street Park.
Seconded.
It has been moved and seconded. Let's take a vote.
Okay, so what's wrong with this picture? It started out perfectly. Mary, a stakeholder of her neighborhood council, was given the opportunity to address the board on the issue of lights for Main Street Park. Where it went wrong wasn't with Mary, but was with the board. It's a violation of the Brown Act for board members of the neighborhood councils to discuss matters or take action on items not listed on the agenda. The issue that Mary raised was not on the agenda because the first time the matter was presented to the board was when Mary brought it up. Let's take a look at the right way to handle the situation.
And that's pretty much all I came to say tonight. Thanks for your time.
Thank you for coming, Mary, and bringing this to the attention of the board. So, what do you think? Should we put this on the agenda for the next meeting?
I agree that we should.
I agree.
We've agreed to put this matter on the agenda at the next public meeting. Any other comments? Any other public comment? Okay, well, the meeting's adjourned.
By placing Mary's issue on the agenda for the next meeting, this gives the opportunity for the general public to come and comment on the issues of the park lights. Now let's look at one more issue.
So what's the deal with Mary? She is really something.
She is.
I know. Well, anyway. That meeting went pretty well, didn't it? Yeah. Listen, while I have you here, I wanted to talk about the park lights and how it's going to affect our other projects. I don't know, I just think it's a lot. The city doesn't have that much money, and...
Now what's wrong with this scene? That's easy. You can't go into an executive session or conduct a private, unnoticed meeting with the board members to discuss items and make decisions. Save it for the next neighborhood council meeting. Also, the Brown Act only allows for closed sessions under very limited circumstances, most of which will not be applicable to neighborhood councils. And in rare instances when your board could discuss an item in closed session, the item would have to be listed on your agenda with a citation to the Brown Act provision that would allow your neighborhood council to go into closed session. So let's recap. All neighborhood councils are considered local governmental agencies since they were created by city charter and city ordinance and certified by the City of Los Angeles. Thus, they must comply with the Brown Act. The Brown Act requires that all neighborhood councils establish a time and place for their regular meetings. A meeting is the gathering of the majority of neighborhood council board members, or whatever number of neighborhood council board members can make a decision on behalf of your neighborhood council. Standing committees of your neighborhood council are also subject to the Act. All the meetings must be open to all members of the general public and located within the boundaries of the neighborhood council area. They must also be accessible to all members of the general public, including persons with disabilities. And they cannot be held in facilities that prohibit the admittance of any person based upon race, religious creed, color, national origin, ancestry, or sex. The Brown Act also requires neighborhood councils to post the meeting notice and agenda. Agendas for regular meetings, including committee meetings, need to be posted at least 72 hours prior to the meeting. Special meetings need to be posted 24 hours prior to the meeting, but there is an additional requirement to notify the media of these meetings if they have made the request to your neighborhood council in writing for notice of your special meetings.
The agenda must include a description of the items and set forth the time and place of your meeting.
You can post your neighborhood council's meeting notice at the meeting site, your public libraries, city hall, and public bulletin boards, or wherever you've decided to post your notices according to your certification application. Do not post on telephone poles, street lights, or city signs. Serial communications among a majority of the board members to discuss matters with the goal of coming to a decision outside the public eye is a violation of the Brown Act. Also, a majority of the board cannot come to a decision on an issue outside the public eye or conduct closed meetings. The Brown Act is set up to allow and protect public access and participation in neighborhood council meetings. Let's keep it that way.